law that protects voting rights for all races and colors is now under threat. Since 1965, a section of the Voting Rights Act has kept a watchful eye on certain states, counties, and townships with a history of bad civil rights behavior. Section 5 of the act says places with a history of trying to restrict voting and representation because of race must get permission from the Department of Justice in Washington before changing any voting districts or procedures. This strange roster of miscreants even includes New York's own borough of Manhattan, but most areas on the list are in the southern United States. And one such place, Shelby County, Alabama, filed a lawsuit challenging Section 5 and what it sees as the invasion of its local power to define its voting procedure. As I mentioned on last night's show, that suit has now reached the Supreme Court. Let's bring in Dale Ho, Assistant Counsel in the Political Participation Group for the NAACP Legal Defense and Education Fund. Thanks for joining us.
Thank you for having me.
Now explain to me, even though I know you disagree with them, why Shelby County feels aggrieved. Why do they want the freedom to define their own voting process?
Right. Well, Shelby County's argument is essentially that we no longer need Section 5 of the Voting Rights Act because the fight for equality in the political process is over. And while it's absolutely true that our nation has seen tremendous progress since 1965, we're unfortunately not at the place where everyone in our democracy can participate as a full citizen on equal footing, and evidence from our most recent election, I think, bears that out.
Now, we're in a very odd moment where those who want the strictures of Section 5 of the Voting Rights Act lifted are saying, look, we just re-elected an African-American president, therefore everything must be hunky-dory. On the other hand, you and others who have joined with you in pushing back are saying, yes, but we only succeeded in doing that because the Voting Rights Act was used to strike down voter ID laws that would have disenfranchised hundreds of thousands.
Right. I mean, so we have seen a lot of progress, and a lot of that progress with respect to racial discrimination and equality in voting is really the product of the Voting Rights Act itself. Have we seen enough progress that we no longer need the act? Well, I think two things from President Obama's election really stand out. The first is we still have problems with election administration. We saw these tremendously long lines, for instance, in the state of Florida. Everyone before the election wanted to know which state is going to be the next Florida. Well, Florida turned out to be
Florida was still Florida.
Was still Florida. And, you know, the last ballot was cast in Florida at 1 a.m., which means that that person had to wait in line for well over 5 hours just to exercise the most fundamental right in our democracy.
But let me push you for a moment. That is not necessarily a racially based act on the part of the state of Florida. That is what we all know to be a massive underinvestment and antiquated process we've created for everybody to vote. So what is the reason that certain counties and even parts of New York State need to get the additional scrutiny from Maine Justice before we change voting process?
Well, the places that are covered by Section 5 of the Voting Rights Act are places that for the most part have really earned their place on that list as a result of a history of discrimination in voting and ongoing problems. And you mentioned Florida and that problem there. Well, what's really interesting about Florida is that in 2008, more than half of African Americans used the early voting period. They didn't have any problems, the state legislature or the governor in Florida, with early voting until that happened. And then 2 years later, in 2010, they decided they wanted to cut back on early voting. And Section 5 of the Voting Rights Act actually prevented the state from making even more draconian cuts to the early voting period than they had originally planned on doing. The lines would have been much worse if not.
Look, you're making the argument that certainly I agree with. I think many of us looking at the evidence on its face agree with, which is that many of these voting process changes that were implemented by state legislatures this year were motivated by partisanship and almost racial animus. Now, what does the Justice Department do when it sees that? Does it simply say you can't do it?
Yes. So when a state that's covered by Section 5 of the Voting Rights Act, wants to change their voting laws, they have two options. They can either go to the Department of Justice and ask for permission, or they can sue in federal court and ask for permission there. What's really interesting is that in this most recent redistricting cycle, for instance, a lot of states decided, you know, we don't want to go to the Justice Department. We want to sue. We want to get our day in court.
Right.
Texas is one of those places. Texas is one of those states that's arguing we don't need the Voting Rights Act anymore. And what a three-judge court in Washington, D.C. found was that Texas's legislature had intentionally discriminated against Latino and black voters. And those judges, two of those three judges were appointed by George W. Bush. So we're not talking about wild-eyed sort of leftists like me who, you know, are accused of seeing...
You don't look so wild-eyed, but that's okay.
We're accused sometimes of seeing racial discrimination everywhere we look. But people across the political spectrum, judges across the political spectrum, when they really look at the evidence about what's happening in these places that are covered by Section 5 of the Voting Rights Act, they've concluded there's still discrimination.
Okay, but that raises what is perhaps a danger, because the rumbling I hear is that the Supreme Court might very well pare back Section 5 of the Voting Rights Act, in which case the judges in D.C. who reviewed the Texas law would lose their capacity to do that.
That's right. That's absolutely right. We're in a situation where we have a landmark civil rights statute that's going up to the Supreme Court, and whenever that happens, there's some concern because this court has not always been the most hospitable when it comes to civil rights issues. But I think we're confident that when the court really looks at this statute, it's really the most important civil rights statute maybe that the country's ever enacted, that they'll see the continuing need for it.
But you have two dangerous convergences here. One is that this is a court that is hostile to civil rights, and it is also a court that on its face likes to be favorably disposed towards state rights. And so it could say, we don't necessarily want to protect civil rights for groups who feel endangered, and we're going to give Texas and Florida the capacity to do what they want, and they may use this as a way to articulate that view.
That's certainly possible, and it's something that we'll have to guard against.
And who was the swing vote?
It's hard to tell. You know, Justice Kennedy is obviously an important vote in this case. I mentioned Texas and its redistricting. During the last redistricting cycle, Justice Kennedy wrote an opinion that said that Texas's redistricting plan bore the mark of intentional discrimination against Hispanic and Latino voters. So he's, I think, sensitive to these issues. He's aware of the things that states have tried to do, and I think he'll hopefully see things our way on this case.
Here's my prediction: that Justice Kennedy pulls a Justice Roberts, and he goes the right way, but leaves Roberts hanging out with the conservative crew. A little payback for health care.
I hope you're right.
Let's see. Maybe we will be. Dale Ho, Assistant Counsel on the Political Participation Group for the NAACP Legal Defense and Education Fund. Thanks for stopping by.
Thank you for having me on.
The makings of a great judge and Chris Christie's judgmental tone on the GOP. All of that coming up on Viewpoint.